behalf of the appellants,
There we go.
Siddhartha Pajidipati and 1010 Capital Inc. I want to cover today 3 points. The first is the wrong standard that was applied by the trial court, the Gonzalez standard, which, although appropriate in the circumstances of Gonzalez, is inappropriate here. The Shelter Cove, the proper standard that should have been applied. And then I want to turn back to the State Farm Supreme Court case that relates to the fair and efficient administration of justice. I'd like to reserve 7 minutes for rebuttal. The first thing to confront is page 14 of the answer brief, where the appellee says that we have sought to disqualify the McIntyre firm based upon their having brought the derivative action on behalf of Mr. Vyas. That is incorrect. If that were correct, then Gonzalez would apply. But in point of fact, we filed our motion to disqualify after the amended complaint was filed. And the circumstances are a bit complex factually, but they're very important because they show the gamesmanship that is at issue here. The original complaint was brought by Mr. Vyas against my clients derivatively because the derivative statute is a creature of equity. The idea being that whoever is locked out of management of the corporation gets to sue on behalf of the corporation. And we all know that normally when you bring a derivative case, at least nominally, one of the defendants is the corporation itself. So obviously nothing about suing derivatively would set up a law firm for disqualification. And that's why we never sought that. Now, we filed a motion to dismiss the original complaint because the company had been reinstated, and under Delaware law, Florida law, you can't sue for a canceled company, canceled under Delaware law. So what they did when they saw our motion to dismiss is Mr. Vyas got together with 2 of the 3 original bunco artists that brought the Q3 fraud scam into being, and he installed himself as the liquidating agent. And that is the right thing to do under Delaware law if the company is going to wind up. Delaware statute 17.803B jibes with the LPA, the limited partnership agreement, 9.02C, to say that the successor to the general partner is going to be the liquidating agent. And that's for all purposes. He brings the lawsuit, if he wants to, on behalf of Q3I LLC. Just like if I were to bring one for our law firm, it would be Anthony and Partners LLC. I don't have to put my name in the beginning, as in a derivative case. And this furtive sleight of hand and the way the case is styled reflects some belief on the part, and ultimately it persuaded the trial judge that somehow the derivative statute still applied. But it was transformative what happened when Mr. Vyas started the case derivatively, but then he brought it directly as general counsel. I'm sorry, as the equivalent of general partner. It has nothing to do with Florida Rule of Civil Procedure 1.210. It has everything to do with the fact that we heard on the record during the dismissal hearing what counsel had done. And let's see, the day before the dismissal hearing, we got an amended complaint where he's bringing the claims in his own name. Now, we said there can't be a creditor because of X, Y, and Z. And that's an element for this cause of action under the limited partnership agreement. Bracketing for the sake of argument, this LPA is part of a fraud scheme. But the bottom line is that counsel said very bumptiously to the court, we're going to be getting a default judgment. Your Honor, you know of a 3rd case pending before you, and we're going to be getting a default judgment against Q3I for the recovery vehicle, the other plaintiff. We were sued 2 times on the same day for the same $3.5 million. So one of them was the recovery vehicle. All you have to do is see the complaint. He signed on behalf of them. And then he also signed on behalf of the de facto general partner for Q3I. Why was he so confident that he was going to be able to get a default judgment? Because he controlled both sides of the lawsuit. All he had to do was talk to Mr. Vyas. He's a liquidating agent. Mr. Vyas not going to show up and defend. In fact, they had the audacity, the temerity, when we moved to intervene so that Q3I could actually get a defense, to say, we're going to dismiss the claims against Q3I, and we're going to dismiss them without prejudice, which means this is a live issue, but we're going to dismiss them. Never explained why. Could it be because they have a huge looming conflict and occlusive judgment was going to be obtained by one McIntyre firm client against the other McIntyre client in order to contrive a result? That's exactly what was going on. He didn't
Mr.
say
Anthony,
it.
let me jump in. Let me take it a step at a time.
Yep.
As you know, the standard review is abuse of discretion, because
I don't believe so.
I'm sorry?
Your Honor, I don't believe so. In this case,
Okay.
the standard that applies is that the standard was wrong. Gonzalez should not have been applied. Shelter Cove should have been applied. You cannot apply a derivative standard when we all know that this is not a derivative case.
Maybe you're misunderstanding me. I'm just saying, I'm referring to the fact that that the standard review for orders entered on motion to disqualify counsel is that of an abuse of discretion. That's what I'm referring to.
Well, Your Honor, I recognize that, but that's only, and that was covered in Shelter Cove, which we can move into. But the bottom line is the lack of substantial competent evidence to support that result leads you to say, number one, the wrong case law, the wrong standard is applied. But then we get to, and Your Honor,
let me then take it, because I just want to be able to take you step by step. So, and the main reason I think why we have this high standard, because everyone has the right to hire their own lawyer. That's really sacrosanct and so forth. But having said this, let's look at what was presented before the court. Okay, I want to make sure, take it one step at a time.
very well.
In this case, as I understand the facts, and correct me if I'm wrong, that we have the McIntyre firm representing Vyas in his capacity as a liquidated agent for Q3I, right? So we have that. And in that action, the liquidating agent is bringing claims, in that case against, I guess, your client. So within this lawsuit, then we also have the McIntyre firm representing let's call it the recovery vehicle, of which Vyas is still a member, right? And bringing claims against the same defendants. So the question before us, and what was before the court seems to me, as I read the finding, came to the conclusion that because because the attorney, the McIntyre firm, did not represent simply the corporation, that was not hired by the corporation, focused its ruling on simply that, came to the conclusion that there was no room for disqualification. So my question to you, Mr. Anthony, is that you have to look as to what type of information the McIntyre firm would be privy to, right? To try to make a determination whether or not they would be disqualified or not?
No, Your Honor. Number one, Shelter Cove, and I recognize that's a sister court, the first DCA, that opinion came out 6 days, at least it was decided 6 days before the hearing before Judge Farfante. But the bottom line is, it is assumed that it is an irrefutable presumption. And I'm citing the first DCA because I think it's right. And I think you will have a direct conflict if you don't follow Shelter Cove. But then let me go to the facts. Let's assume arguendo that it's not de novo review because Gonzalez is clearly inapplicable. Gonzalez relates to when somebody sues because they're not in charge of the company. But for the amended complaint, he was entirely and exclusively in charge of the company. Well, now let's take a look at the conclusory and self-serving affidavit which the court relied upon. The first 3 paragraphs say what they say. The rest of them, I didn't get paid by Q3I. Well, that begs the question. The Mansour case and the Florida Bar versus King show that all of this is irrelevant. For him to say my law firm never represented Q3I is false. It is belied by the amended complaint itself. We know what Delaware law says. We know what the LPA says. He is the exclusive agent for the company for purposes of wrap-up. And that's why when you take a look at the 5th DCA in Morse, with that, they say it's the substance of this. It's not the fact that the trust is out there and that we're dealing with assignees of the heirs of the estate. The bottom line is it's a direct conflict. Now, the most important case on point is Shelter Cove. And it says, and that does deal with abuse of discretion standard, and it relates to findings of fact that were very nitty gritty. But that's a receiver. The law firm Carver Darden represented the receiver and then attempted to represent a third lien holder. And a receiver they found had enough traction for the HOA, the original client, to say that was a conflict. Now, a receiver is a lot less than a general partner or the statutory successor to a general partner, which is a liquidating agent. There's no way to get to a different result under Shelter Cove than what we're urging. And of course,
I think you misunderstood me, Mr. Anthony. I think you're agreeing with me that Shelter Cove does apply. And I think when I asked you that initial question, perhaps I misunderstood your response, or maybe you misunderstood my question. You're basically saying that you really don't need evidence and confidential information because of the presumption. And we're dealing with Shelter Cove in this case. So I guess the question for us is that the McIntyre firm basically are proceeding with 2 things. They're doing one thing, and then they're also doing another thing, which under Shelter Cove may be problematic.
And Your Honor, it's worse than that, because the truth of the matter is, when you look at the State Farm case, and then you read our appendix, page 189 to 216, and 536 to 538, you see in great detail all the labor that the law firm did to set up Mr. Valles as the sole decision maker for Q3I. And when did they do it? They did it after we filed our initial motion to dismiss to the derivative complaint. And then they came in the day before, the day after they amended the complaint, they came in and said, oh, we are very confident that our other client, that's the only way they would have been able. They weren't omniscient. They couldn't see into the future. So somehow they must have known that Mr. Valles, their other client, was not going to defend in that case. And the most telling and really shows a bit of audacity is that then they went in afterwards and moved to set aside the default that they were pronouncing that they were going to get when they spoke at the dismissal hearing, because they figured out that they had served themselves wrong. So they appointed a registered agent, and then they said, we want to vacate the default against our client, and then we'll move to default again now that we have proper service.
Okay, but before Mr. Anthony, before you get too far afield, I have just one question, because I think you're going to get into your rebuttal time. And Judge Northcott, you're about to tell him that he's getting into his rebuttal time.
You know me so well. You know,
okay.
I always say use the time as he pleases. So, but
okay. All right. Let me ask you that, because I don't want to assume that there is in fact a conflict. Why does your client have standing to raise it? Because you're not the former client, and isn't K3I, and K3I is 3, whatever, isn't a party. I want to make sure that you address it before we lose track of time.
I appreciate your honor. The Ironstone case stands for the proposition that special informational advantage matters. And we know that they brought special informational advantage to them at the dismissal hearing. They're cooking up the reinstatement of the company that's been canceled. They're already using it, whatever it says in the conclusory affidavit that's so tersely worded. as to be, these thaumaturgic incantations of, I never represented them. The note itself to 4-1.7 contemplates that in situations like this, where you're implicating the process and fairness and justice, that like the State Farm standard, a third party like us can intervene. In State Farm, you had the law firm involved was representing the husband, the wife, and the daughter. They decided that it would be easier to play the the insurance company if the husband were dropped and then sued. The husband agreed to roll over to the extent of insurance coverage, and the insurance company said, "What's this all about?" I have to say this, Your Honors. My client is gullible enough to put $3.5 million into some sort of a fraud scheme tied to a cyber currency algorithm, but he is not gullible enough to think that this is a fair system of justice when counsel is cooking up a fake and collusive judgment in order to satisfy the one creditor rule and pursue a claim under this LPA. It shakes the foundations of our litigation system for me to try to explain that to a medical profession. Thank you, Your Honor.
Okay, Mr. Anthony, you have about 5 minutes to go for your rebuttal. So,
All right, thank you, Your Honor.
okay, Ms. Jones.
Thank you, and may it please the court. My name is Jennifer Jones of the McIntyre firm on behalf of the appellee, Sanket Bias, as the liquidating agent for Q31LP.
And Ms. Jones, I want you to give you the same consideration for Mr. Anthony. All right, we talked about the Shelter Cove, and I know the trial court was not relying on that. They just thought the other case was more. Help me out. Why we're not dealing with a derivative action here? Tell me why Shelter Cove should not be followed in this case.
Well, Your Honor, it's factually very different from the instant case. The Gonzalez case is the one that's factually more similar to the instant case. So for Shelter Cove, first, I will point out that Shelter Cove agrees with Gonzalez that it's an abuse of discretion review for this court, and that's at Penn Site 226. So the two cases are in agreement on that. The second thing for me that stands out in Shelter Cove is that there was no dispute that an attorney-client relationship existed between the attorney in question and the receiver. And that's throughout the case that the court repeatedly says there's no dispute that an attorney-client relationship ever existed. And I'm at Penn Site 227, where the court said, at the hearing below, Carver Denver never argued that an attorney-client relationship did not exist. So in that particular case, the attorney in question had represented the receiver. And then when that receiver went away, a different receiver came on, that attorney went away. That attorney came back representing a bank on the same lien that he had been charged with by the receiver imposing. So there was never a question in Shelter Cove that the attorney in question, represented that receiver, and that then he was coming back in the same action and representing the bank against the receiver, who was the subsequent receiver at that point. The other thing that stands out to me about Shelter Cove is that it's a 4-1.9 case. So it's a representation of a former client case. And my understanding based on the briefing and the reply briefing is that the appellants are not making an argument under 4-1.9. In fact, that would have been waived because it wasn't actually made below that there was some sort of a former client relationship here. 231 would have been a former adversary in the recovery vehicle case, which was case number 2402. But there's no basis to say that somehow 231 was a former client of the McIntyre firm. So for me, Shelter Cove is really not on point at all, other than the fact that it involved a receiver, which is a similar situation to a liquidating agent. But the similarities end there with Shelter Cove. And my reliance on Gonzalez is more closely akin to the situation that we have here because of the relationship between the company and the derivative plaintiff that was described in the Gonzalez case. So the stockholders' derivative action is brought by and on behalf of or for the benefit of the corporation, just like the liquidating agent in this case is bringing the action for the benefit of 231. And so in that way, the two situations are aligned.
But wouldn't you agree, Ms. Jones, that at least both cases do focus on the confidential information, whether it's former or current? Isn't that what we need to look at? And if you accept that in this case, isn't there confidential information provided when that McIntyre firm is wearing these two hats?
No, Your Honor. So I'm going to try to back that up just a little bit so that we can kind of talk about how this happened. So Q31 is a partnership. It's controlled by a general partner, which is Q3 Holdings. And then it has a bunch of limited partners who have no ability to do anything with the company. Q3 Holdings is who is currently and was always in control of Q31. I heard opposing counsel's statements that the liquidating agent is a de facto general partner or a successor to the general partner or equivalent to a general partner. I don't know where that's coming from. I have not seen that in the Delaware statutes or in the partnership agreement. That the liquidating agent is very different from the general partner. In fact, it's the general partner that provided the authority for the liquidating agent to just wind up the affairs of the company. And that is in the VS affidavit that was in the Appellee's appendix, starting at page 9. We included there all of the authority that was provided by the general partner to the liquidating agent to try to wind these affairs up. So the general partner is and always was still in control of Q31. There's no confidences of Q31 that somehow the McIntyre firm would be privy to that weren't actively shared by Q31, meaning Q31 sought to have McIntyre pursue this particular claim. So what happened in the with the dismissal, because again, I heard a lot of comments from opposing counsel about the fact that Mr. Thanasidis pointed out there was going to be a default judgment. That's because the complaint had been unanswered for over a year and a half. So the complaint in the 2402, which was the recovery vehicle case, the complaint sat there from March of 2020 and hadn't been answered the entire time. So there was no nefarious behind the scenes wheeling and dealing going on. It was just a matter of it hadn't been answered. So I think it's pretty clear that the recovery vehicle would be entitled to a default judgment at that point when they had declined to answer the complaint, and then again the amended complaint when that happened. So there's no special information exchange happening or confidential information exchange happening between Q31 and the attorney for the liquidating agent. And I think that's really an important point, because for me, the critical issue in this is whether the liquidating agent's attorney automatically becomes the attorney for the company being liquidated. And the answer to that has to be no. And we see many examples of this. The derivative plaintiff in Gonzalez. The derivative plaintiff's attorney is not automatically.
But that's different. The derivative, as I understand it, Ms. Jones, derivative claims are a little different. We're dealing with an individual Vias who's proceeding with the liquidation of this company. And forgive me, I'm going to try to make it very, I guess, basically saying his obligation is, hey, what are the assets? What are the things? I need to find out all the information in this corporation so we could figure out as a liquidated agent, where's all the money, where's the liabilities and so forth. So you have a lawyer representing him. And the same lawyer now represents the recovery agent, the company that's trying to sue in order to claim some of these assets that may be out there. So I guess it goes back to my question. Isn't there some, when I say confidential information, that the lawyer is privy to information from the liquidating agent because he has access to all the books, all the information, all that stuff, but yet he's wearing another hat that, oh, I get to sue in order I could recover. This is where I'm having difficulties with, so help me out.
Your Honor. So first, the liquidating agent does not have access to all of that information. That's the state of affairs. There's no evidence in the record that the liquidating agent has access to all of that information. All of the authority in this case that the liquidating agent has is coming from the appointment by that general partner, Q3 Holdings.
But isn't it common sense that if you are the liquidated agent, what does a liquidated agent do? They have to go in, they're gonna have to liquidate that, go through the whole thing, setting forth, okay, what are the assets? What do we have? What it is in order for it to basically take care of all that. And so isn't that what his role is?
No, Your Honor. So in this particular case, his role is defined by a couple of things. By the appointment papers, which were attached to the VS affidavit, that defines what the liquidating agent's role is, and then also by any law that would be applying. So he doesn't have unfettered discretion to do anything. And in fact, if the general partner decided that the liquidating agent wasn't doing something that they didn't like, the general partner could fire or remove the liquidating agent. So he's much more constrained. He doesn't have what I'm hearing you describe is sort of an unfettered discretion, like a trustee in bankruptcy.
No. But so tell me, so what will Mr. Bias do? Tell me, what will, in this case, Mr. Bias will be doing as a liquidated agent?
In this case, he is suing the claim against the appellants for the return of distributions that were made to the appellants, which is required under the partnership agreement to be returned to the company in the case of insolvency.
And how about the language of the LPA? I mean, if we could look at the language itself, let me see if I could pull it.
Yes, Your Honor, I think
doesn't it say that the LPA makes clear that the liquidating agent has the powers and duties of a general partner in winding up and distributing assets, among other things, quote, shall conduct or cause to be conducted a full accounting of the assets and liabilities of the partnership. That's where I'm troubled with.
And I'm sorry, which record page are you on, Your Honor?
I'm looking at the LPA that you have, that's in the record.
Okay, and which section? I'm sorry, Your Honor.
I don't know where, because I actually pulled it out and I have it in my little notes here. So I don't recall exactly where I got that from.
Okay, so.
But it's in the record, and this is the language that I got from the LPA agreement.
Okay, well, again, I mean, I think in this particular case, it's governed by the appointment that the general partner gave to.
Oh, here it is, Ms. Jones. It's section 9.02A.
Okay, and I have 9.02C out here, so let me just make sure I'm looking at the same thing.
Yeah, it's in appendix, I think 416.
Yes, Your Honor, I've got that. Okay, so section A is talking about the dissolution of the partnership, and my understanding of where the partnership is right now is that it has not yet been dissolved. So it still exists, and the general partner is still in control of the partnership right now. So I guess maybe that's part of what the difference is. And I think for me, the problem with the appellant's position is that I think it would fundamentally change the nature of attorney-client relationships in the state, because that's a subjective determination based on what the attorney and the client intend. That's straight out of the Gonzalez case that tells us that. And in this case, what we have is we have no evidence that Q31 ever intended an attorney-client relationship with the McIntyre firm. We do have evidence the McIntyre firm never intended an attorney-client relationship with Q31. It was the burden of the moving party to provide us with any evidence that Q31 intended for there to be an attorney-client relationship. There's just nothing in the record that indicates that there was any sort of an attorney-client relationship intended or formed between McIntyre and Q31. And so if the appellant's position were found to be correct, we would be fundamentally changing the way that attorney-client relationships are formed.
And I don't follow that, Ms. Jones. I don't follow that.
So in this particular case, it was Mr. Vias who hired McIntyre firm.
Correct.
Appellant's position would then say that somehow, because Mr. Vias hired the McIntyre firm, now the company that has appointed Mr. Vias to liquidate it is also a client of the McIntyre firm. Now we see this with, trustees, with receivers. They each have their own attorneys. Those attorneys do not represent the company, just like with the derivative plaintiff. And I do recognize that Your Honor believes that is a little bit different. To me, they're both acting in their individual capacities for and on behalf of the entities. They both owe the fiduciary duties to the companies. And so to me, they're quite similar. So I guess I'm concerned about expanding the scope of attorney-client relationships outside of the party actually engaging the attorney and intending for the attorney to be their attorney, and then the reverse, the attorney intending for this person to be my client.
Well, and I'm not suggesting that. My main concern is Vias himself as the liquidating agent. What information is he privy to? That's when, and we look at the LPA, what it is, what is his obligation? And then he has the same attorney that's representing the recovery. I guess that's where I'm concerned. And this is where I'm coming from. I'm not suggesting changing the whole law about, and I agree that a client has absolute right to hire his attorney of choice, but we have to be careful and to make sure that no conflict arises. And this one, honestly, it just seems unseemly that we're dealing with the same lawyer, basically wearing, the two hats here, dealing with conflict. It just troubles me, Ms. Jones.
And I want to resolve those troubles for you. I guess the first thing is that there is no current conflict because the claim against Q31 in case number 2402 was dismissed. So there exists currently no conflict. That moots the issue really from a practical perspective, because there exists no current, there is no lawsuit in which McIntyre is representing a party at this point that's suing Q31. And then I guess my second thought on that is who has the ability to assert that conflict? It would have to be someone who is a client of McIntyre. So perhaps Q31, or I'm sorry, perhaps the recovery vehicle could assert that. Mr. Vias could assert some sort of a conflict. But assuming that there's this, my problem with the appellant's position is that it assumes an attorney-client relationship and then says there's an irrefutable presumption that that confidences were shared between the parties because of the assumption of the attorney-client relationship. But that the existence of an attorney-client relationship is exactly what's in dispute here. And that's where it diverges. So there simply isn't an attorney-client relationship between Q31 and McIntyre that would give rise to any sort of irrefutable presumption. And the other,
and I just wanted to correct you, Ms. Jones, because I think you said only a client could raise this. I think the Florida Supreme Court already weighed in on it, that even third parties can as well. And I know you didn't mean that, but I want to make sure to clarify that.
yes, and I appreciate that, Your Honor. There is a narrow exception to the privity requirement that does say someone can stand in the shoes of the person who would have the ability to move for disqualification. And that's the standing argument. And the appellee would assert that the appellant does not have the ability to stand in the shoes of Q31 here. There simply isn't any way for the appellant to do so. There are no shoes to stand in, as one of the cases said. The appellant may be a limited partner of Q31. That's unclear right now based on the different positions that the appellant has taken. But if the appellant is a limited partner of Q31, the limited partner does not have the authority to act on behalf of Q31. So it's unclear how the appellant would have the ability to stand in the shoes of Q31. Certainly, this is a different situation than that with an insured and the insurer, as was in the case, the State Farm, I believe it was a State Farm case, where the family was represented by one attorney and then the father was no longer represented by that attorney. So I suppose for me, and I know we disagree about this, Judge, but I believe that the Gonzalez case is controlling here, is more similar than the Shelter Cove case. And again, I would point out that Shelter Cove, there was no dispute that the attorney represented the receiver and that there was an attorney-client relationship there. Shelter Cove was a former client case, a 4-1.9 case, which has not been raised below here, and that argument was waived. So I don't believe that Shelter Cove is more applicable in this case than the Gonzalez case. And for those reasons, the appellee would respectfully request that this court affirm the trial court's ruling denying the motion for disqualification brought by the opposing party on abuse of discretion review.
Thank you, Ms. Jones. Excuse me. Mr. Anthony, 5 minutes for rebuttal.
Yes, Your Honor. I would read verbatim if I was going to lose time on it. And also if Judge Kuzum had not already covered 9.02 sub A and sub C, make it very clear. There's no general partner anymore. And 2 of the 3 hoodlums who perpetuated the fraud scheme got together with Mr. Vias and the McIntyre firm to install him as the successor. That's irrefutable. Now, I view the arguments that I've heard askance because if we were here on a Chapter 90 issue talking about attorney-client privilege, I feel pretty confident that counsel would say there's an attorney-client relationship here. But right now, for expediency, she says there isn't. We identify, in fact, counsel conceded she said, well, in a receiver, it would be different. Well, this situation is different. It is more obviously an embodiment of the company, and the Delaware statute makes it very clear. Elon Musk does not have to sue on behalf of Tesla. It's just Tesla. They contrived the style of the case to make it seem otherwise. As far as the conflicts, my client, theoretically, let's put it clear. My client put in 3.5 million. He took out 3.5 million. He did not lose money. He did not gain money. And that's the reason why we're here. But the specific reality is, if theoretically our client gave up money in connection with, for example, the recovery vehicle case, he'd be unable to receive it back at pro rata in the Vias case, which would be for all 150 victims. So there's an obvious, we got sued on the same day, May 1 of last year. We got sued for $3.5 million for 2 clients, both represented by the McIntyre firm. They didn't file them in the alternative as 2 plaintiffs. They were assigned to different circuits. All of this taints the situation. This is why we have a Ken Ayre situation, why changing horses and wearing different hats, whatever you want to call it, there is a gross and palpable conflict that was contrived in order to give a cause of action some legs where you needed to establish the existence of a creditor. And they could not have done that unless the McIntyre firm were shepherding it on both sides, holding up one client as the plaintiff and pushing down the other client to obtain a default judgment. And when they realized they hadn't served them right the first time, they served them the second time, removing any doubt, and it's in your record, removing any doubt, they said, and we'll move for default again now that we got them served right. And to say that that's not a current conflict when they dismissed 6 days before the disqualification hearing and said, we're dismissing our claims against Q3I, that's performative. That proves what we had suggested all along. Thank you, Your Honor.
Okay. Thank you both very much.